Can Netflix change its monthly subscription fee and continue charging customers without letting them know? And can Uber Eats shift all responsibility to its restaurant partners for any issues and faults with an order? These scenarios are potential examples of unfair terms. When we make online purchases, download software, and utilize a variety of online services, whether as a single consumer or a small business, we are entering online agreements. As such, these online agreements also attract protections under the Australian Consumer Law, or ACL. So how does the ACL's unfair terms apply to online contracts? Section 23 of the ACL stipulates that a term of a consumer or small business contract may be deemed void if the term is unfair and forms part of a standard form contract. A few key terms resonate from this section, which we will now explore. So what type of contracts are protected under these provisions? This provision applies to consumer and small business contract. A consumer contract is a contract for either a supply of goods or services or a sale or grant of interest in land. A small business contract is similar to that of a consumer contract. However, the business must employ less than 20 people, and the upfront cost must either be less than $300,000 or for a contract that is more than 12 months, less than $1 million. So what makes a term unfair? A term will be unfair if it causes an imbalance in the party's rights and obligations. The term is not necessary to protect the legitimate interests of the party who would be advantaged and would cause a detriment to a party the term was applied or relied upon. A pertinent example of unfair terms comes from Uber Eats' previous contracts with restaurants. These contracts made the restaurants responsible for the delivery of meal orders, thus resulting in the restaurants being financially liable for all refunds issued by customers, even where the restaurant was not at fault. Following an investigation by the ACCC, these terms were found to be unfair and subsequently amended by Uber Eats. Finally, what is a standard form contract? While not defined in the ACL, a standard form contract is a contract that is identical or substantially similar contract that is offered to all consumers or small businesses. They act on a take-it-or-leave-it basis and leave no or little room for negotiation. For online agreements such as click and browser wrap agreements, whereby a consumer clicks a button to accept the online terms and conditions without being able to negotiate them, is an example of a potentially enforceable standard form contract. Some examples of these contracts that we may be familiar with include the Apple Store's terms and conditions, a monthly online entertainment subscription such as for Netflix or Stan, or the terms of service for a ride-sharing app such as Uber. The effect of this provision is that a consumer or small business may seek in order to render an unfair term void. However, the contract will continue to be binding if the contract can operate without the term. Ordinarily, penalties will not apply to parties who have unfair terms, unless it falls under other ACL protections, such as false or misleading conduct. So, what have we learned today? We have learned that the ACL affords protections to online consumers and small businesses for online contracts that they may enter. As such, the contract must be recognised as a standard form contract, must be deemed unfair, and must be for a consumer or small business. The result of this is that the term will be deemed void. Thank you for listening.